So on to Lively's opposition to Wayfarer's motion eliminate number 4, which is seeking to preclude all references to other clients of Melissa Nathan and Jed Wallace. Now, Lively actually spends quite a bit of time on this one, so this is going to be a bit longer, but let's go through it. I am anticipating references to Johnny Depp, who is a former client of Melissa Nathan, and references to the Bam Margera lawsuit against Johnny Knoxville and others in the case of Jed Wallace. Let's go. Defendants seek to exclude exhibits referencing clients of Melissa Nathan and Jed Wallace under Rules 402 and 403. While Lively agrees that the identities of certain Nathan or Wallace's clients may be properly redacted as irrelevant to the claims at issue, several aspects of their client work and clientele are directly relevant and highly probative of Lively's claims. 1. The services of Wallace either described himself actually performing or at minimum offered as services he was capable of performing to powerful and influential individuals around the same time Wayfarer engaged Wallace to perform exactly the same issues. 2. Nathan's prior representation of Johnny Depp. Well, there we go. I don't see the relevance of that. Johnny Depp was, he won his case. He was found to have not abused. Like, it was a court has literally deemed that Amber Heard lied about the sexual violence that she supposedly experienced. So I don't know why they keep trying to use this as a flex. It's a man who was falsely accused. And in that case, the court has deemed that he was falsely accused. Amber Heard lied. So all I'm getting is that Melissa Nathan, has represented now more than one falsely accused man. 3. The identities of redacted and the redacted. So, okay. And if Bam Margera is part of this, I do expect him to be redacted because he has not been made public, but obviously there was a whole lawsuit where, Jed Wallace was one of the defendants. So, which I have done a video on, and I will put a link to that. Okay. Both of whom are relevant to digital campaigns conducted by Nathan and Wallace. Oh, there'll be Rebel Wilson as well, of course. Each of these facts, as described herein, is essential to challenging the credibility of Nathan and Wallace, who during their depositions testified under oath not just that they did not take any actions to manipulate online narratives about Lively, but also, contrary to numerous of their own text messages and emails, insisted that they had never engaged in such activities and would not even understand how to do so. As such, the documents defendants seek to exclude are admissible. During his deposition, Wallace repeatedly insisted under oath that his redacted and that his company Street Relations does not redacted. Wallace further testified remarkably that Street Relations has no commercially sensitive, proprietary, or otherwise secret methods, tools, or techniques that give it a competitive advantage. He testified that neither he nor Street Relations were redacted, including, among other things, redacted. And then something's redacted or redacted. Wallace's communications with clients, prospective clients, and other individuals he disclaimed as clients, yet performed considerable services for during the relevant period of time, prove that these are precisely the types of services he routinely offered and performed. The fact that TAG routinely sent out descriptions of Street Relations capabilities during these services is directly relevant to rebutting the defendant's mantra that the only thing they understood Wallace did was engage in the monitoring of online activity. Moreover, Lively has the right to challenge Wallace's credibility in testifying that because he didn't even Moreover, Lively has the right to challenge Wallace's credibility in testifying that because he did not even understand what the services described in his own scope of work document were, he could not possibly have performed them for a Wayfarer. The jury is entitled to consider Wallace's considerable contemporaneous communications in which he admits not just that he knew what those services were, but that he regularly performed them. The jury must be allowed to review these messages to decide whether Wallace was lying when he wrote them or was instead lying when he insisted under oath that he redacted and that the redacted. Lively's need for this evidence is compounded by defendant's spoliation of critical communications. Wallace admitted that he redacted. With those communications permanently destroyed, Lively has very few contemporaneous messages between Wallace and Tagg that document the digital work Street Relations was performing on behalf of Wayfarer. Instead, the jury must make inferences, and to do so, the jury is entitled to consider the evidence of the services Wallace was offering to and conducting for other clients at the time in assessing the credibility of Wallace and Nathan's monitoring-only narrative. Okay, a couple of things. So firstly, Lyman has not ruled on the spoliation motions, the sanctions motions. There's no ruling on that at the moment. I also have I don't like what the argument that's being made here. It's a decent argument. Lively's counsel have got to make it, I guess. But to say, well, he's done this for other clients, so therefore, we've got to take it as a given that that's what he did for Wayfarer against Lively. That does not prove the case at all. So I don't like that. Now, yeah, they might want to attack his credibility if he did say in deposition, well, I don't know how to do these things, if there is evidence of him doing those things. But again, that's a credibility issue. That is not like, well, he did it for these 3 clients, so therefore, we can all assume that he definitely did it here for Wayfarer, because that is not how that is going to work. And it could be unduly prejudicial, actually, to Wayfarer. Wallace's deposition testimony underscores why the identity of those for whom he was performing services, some of whom Wallace insisted were not his clients, is far more probative than prejudicial. When confronted with contemporaneous communications like the one described above, Wallace dismissed his representations mere redacted or denied engaging in the conduct described. But the identity of the individuals to whom Wallace claimed to be making misrepresentations about his own services is directly relevant to whether his redacted claim is credible. This is particularly true with respect to one of Wallace's contacts, who he disclaimed as a client, redacted. The stature and prominence of redacted, including the potential professional consequences of making written misrepresentations to a redacted, makes it less likely that Wallace was misrepresented in private the nature of his capabilities and ordinary work, and far more likely that he has written descriptions of his services should be credited. I think that's supposed to be his, and far more likely that his written descriptions of his services should be credited over his subsequent false and self-serving deposition testimony. In that instance, the identity of the client is not merely relevant, it is essential. The fact that Wallace and Street Relations are no longer parties to this action is irrelevant to the admissibility of Wallace's testimony and documents. Wayfarer retained Street Relations and paid $90,000 for 3 months of Street Relations services. The services that Street Relations performed on Wayfarer's behalf as part of that engagement are directly relevant to Lively's claims against defendants, and the statements that Wallace made regarding the work he was performing for Wayfarer are plainly admissible as an agent of Wayfarer. Nor does it matter that Wallace has elected not to appear live at trial. Under Federal Rule of Civil Procedure 32, Wallace's deposition testimony is plainly admissible against defendants because defendants were represented at the taking of the deposition, and Wallace is more than 100 miles from the place of the hearing or the trial. The same conclusion should be reached as to Nathan's representation of Johnny Depp during his highly public trial against Amber Heard. On August 13, 2024, The Hollywood Reporter published a story reporting that Baldoni retained the services of Melissa Nathan, who represented Johnny Depp during the Amber Heard trial. This revelation came at an important turning point in Wayfarer's retaliation campaign against Lively, and Lively will now testify about how Wayfarer's retention of Johnny Depp's crisis PR team influenced her understanding of Wayfarer's conduct at that moment in time. This is the same woman, this really stupid, hypocritical woman has retained Johnny Depp's expert witness, Richard Marks. What I'm not actually sure what the conclusion is she's trying to get here. Melissa Nathan once represented Johnny Depp. So fucking what? He was exonerated from the domestic abuse he'd been publicly accused of in a very similar way via a large, mainstream media outlet. I just find this absolutely fucking insane. He won his trial. And to be honest, if she's hoping to try and bring in the UK trial judgment, I will be rather pissed off, because that was the most biased crap I've ever read in my life. And I am trained and qualified in UK law. And that's my assessment of that, having read it all. It's not just mine, the it's Daniel's as well, the black belt barristers, right? That is such a biased judgment, and it is completely wrong. So I'm not quite sure what the purpose is of this, but let's continue. But I'm just so frustrated by this, because I wouldn't even be able to say this, right, had she not just gone and paid a lot of money to the guy who testified on behalf of Johnny Depp at that same trial. She's engaged his expert witness. This revelation, right, oh no, I've read that. Ugh. The point is not that Nathan was immoral and a wrongdoer, but rather to underscore how Lively understood the torrent of online hatred that appeared virtually overnight on the heels of premiering a box office smash. Further, the fact that the Hollywood Reporter article specifically references Johnny Depp is directly relevant to evidence that impeaches Nathan's credibility. The day after the article was published, Baldoni told Nathan that he was redacted, specifically redacted. Nathan responded to her client's frustration about having been linked in the press to Johnny Depp by falsely accusing two different people for having leaked the fact of Tag's retention by Wayfarer to the Hollywood Reporter. With certain audiences, Nathan fingered Lively's publicist, Leslie Sloan. Well, God, that's not a good way. Maybe we should not be writing sentences like that. With certain audiences, Nathan fingered Lively's publicist, Leslie Sloan. Now that's sexual harassment as being behind the story, even though Nathan told Sloan herself that she knew Sloan had not placed the article. With others, including Jennifer Abel, Nathan blamed Stephanie Jones. All the while, Nathan conceded her knowledge, documented in her text messages, that the Hollywood Reporter learned about Tag's representation of Wayfarer from Nathan's own friends. At her deposition, Nathan insisted that these text messages were just jokes, but the jury cannot evaluate the credibility of that self-serving claim without understanding the content of the article or why it so upset Baldoni, namely the Depp comparison. The facts surrounding the publication of the Hollywood Reporter article go directly to Nathan's credibility when she testifies, as she testified to repeatedly during her deposition, that Lively and her publicist had placed multiple negative stories about Wayfarer with the press in August of 2024, and that Tag was merely responding to such stories in self-defense. Lively must be permitted to elicit testimony and introduce documentary evidence regarding the Hollywood Reporter article and Nathan's representation of Johnny Depp to allow the jury to assess Nathan's credibility. Finally, Lively intends to present evidence that Nathan and Wallace have worked collaboratively, including at the same time as the events in question in this case, to create websites to harm the reputation of their clients' foes or bolster the reputation of their clients. To do so, Lively will inherently need to identify either the clients or the targets of Nathan and Wallace's efforts, including redacted target and redacted client. Okay. That still does not prove Lively's case. I feel like that's important to be said. Even if there is evidence of this, and actually I believe there probably is, because I have shown the dark side of Jed Wallace, and as much as I have, been an avid supporter through this case against Lively, because I can plainly see what Lively is doing and where she's lying about him. And I did feel very sorry for him, and I adored his attorney, Charles Babcock. But yes, Wallace has a dark past where, he has done unethical stuff. Absolutely. And I have been the first person to lay it out in this case anyway. But that does not prove that he did anything, basically. It doesn't prove that Wayfarer engaged with Nathan or Wallace for the purposes of retaliation. If it is proved that Nathan and Wallace did things off their own, off their own kind of back, because that's how they operate. But there is also evidence of Wayfarer clearly saying, we are not doing this, we are not doing that, we do not use bots, so on and so forth. Make sure that this is not coming from us. Then it's going to be really hard for Lively to sort of argue that, this is part of a smear campaign due to protected activity in the workplace. The relevance of this evidence is, again, to impeach the credibility of Nathan and Wallace, who both not only denied participating in the creation of any such websites, but disclaimed even the understanding of how one would go about doing such a thing. Yet again, this self-serving testimony is directly contradicted by their own text messages, a voice note, and the under oath testimony of Nathan's employee, Katie Case. Evidence that Nathan and Wallace lied under oath about their involvement in the creation of multiple digital campaign websites is admissible because it is highly probative evidence of whether they are also lying about their involvement in a digital smear campaign launched against Lively, as well as their insistence that all Wallace and his company do when working with Nathan is engage in monitoring. To the extent that such evidence is prejudicial, that is a problem created entirely by Nathan and Wallace's deceptive testimony. The issue would be entirely different had they simply admitted to doing the things that they described doing in their text messages and emails. Yeah, I don't disagree, actually. If they just said, yeah, we can do these things, but we didn't do it in Wayfarer's case, then that would be quite different. If they've denied something and then there's actually evidence that they're not being honest about it, then that's a problem. And it does bring into question their credibility. For the foregoing reasons, Lively requests that the court admit into evidence 1. Wallace's communications with other clients evidencing his capabilities in the digital space as well as the identity of redacted. 2. Nathan's representation of Johnny Depp. And 3. The smear websites created by Nathan and Wallace and the identities of the clients or targets associated with those websites. Okay, so yeah, I do think that that Lively's arguing for the names of everyone who was involved in the Bam Margera case that was brought that included Jed Wallace as a defendant. And the reason I think she's hooked onto that is because if you look at all of the list of Lively's attorneys, right, she's got one for the Texas case against Jed Wallace, right? Laura Prather. Laura Prather was Jed Wallace's attorney in his defense against the lawsuit that Bam Margera brought against him and Johnny Knoxville and a bunch of other people and entities. So Lively actually hired Jed Wallace's former attorney from the Bam Margera case. And then obviously the smear campaign website, the clients that she wants unredacted there are going to be people like Amanda Ghost, Rebel Wilson, etc. And there'll probably be other people as well. I can't think of off the top of my head, but those are the big names that stand out with me. So yeah. Okay, I'm going to stop here. And I'm going to do the next video, which will be on motion and eliminate number 5 to preclude evidence and argument relating to pre-trial filings and the court's ruling.